really strikes you about Dr. Pettit is his strength. No matter what the situation, he's always willing to take the lead. He speaks to reporters right after this verdict, and he says things that show support and positivity, mentions his foundation, how he's trying to help people. Unbelievable man. In the face of such tragedy, he stands tall. Let's go to in-session correspondent Beth Karras. She's right there outside the courtroom. Also, criminal defense attorney Keith Murray. He used to clerk for Judge Blue, and he's also been involved. He's been following the Hayes trial. Thank you both. And Keith, I want to start with you. Dr. Pettit talking about how the jury was diligent in this case, but he also expressed a little bit of surprise, didn't really understand about the arson not guilty verdict. Do you think that in some ways the jury could have been saying, look, let's err on the side of caution here? It may not be clear to us who set that fire?
No, I think, as I've said before, jurors rise to the occasion. They take this job very seriously, and even though they may have all been of the same mind with the guilty verdict on the first vote when Judge Blue ended the charge and they first got the case, they will still very methodically go through the evidence. And I think this is a sign that they were very diligent and very analytical in looking at the language of the Connecticut statutes as they pertain to the charges and the facts that they heard. They made a very clear distinction that arson is of whatever the material is. Arson is not putting the material there. It's the ignition of that material. And that was a very reasonable question. It was a very logical question. And I'm not surprised that they came back the way they did on that charge if they believe that Hayes was out of the house before Commissar Jeffsky. The last person out, as Tom Ullman made a case, is the person who's going to set the fire. You're not going to set the fire with your partner still in there.
Okay.
So I think it makes sense.
Okay.
I think it makes sense.
So if that part makes sense. And Keith, in this case, we saw the community also caring right back, being there for the family, supporting them. Have you seen anything like a case like this in terms of support for Dr. Pettit and his family?
No, the last death penalty case here in Connecticut was the Jonathan Mills case. It didn't receive nearly as much national attention. Even the local publicity was not as on as with this case, and I think a large part of that reason is this is a truly exceptional family. When finding out about their mother's illness, the daughters rose to the occasion. Both parents are professional. They're pillars in the community. They're very well thought of even before all this happened, before they got on the national radar. So I think that has an extra tug at people's heartstrings as opposed to a death penalty case or a serious murder case where it's a little more depressed neighborhood and you don't have this idyllic family that we have in this case.
And Keith, what impresses me, astounds me, I should say, Dr. Pettit there every day during the trial. I just want to ask you from your experience, have you ever seen a defendant in such a highly charged case like this be there every day for his family?
Yes. It typically happens in cases like this. I remember in the Penny Sarah murder trial, Penny's sister was there every day of the trial. In the Jonathan Mills case, I don't remember people being in there every day of the trial. I remember the victim's family members were there, but from the defendant's side, no.
Okay. All right. Keith, Michael, thank you so much. It's so hard to imagine how they could have such strength, but time and time again, Dr. Pettit has risen to the occasion and really supported the community, and they support him right back. Thank you so much, guys. All right, folks, let's bring back in session field producer Michael Christian and criminal defense attorney Keith Murray. Keith Murray used to clerk for the judge in this case, Judge Blue, and he's been following the Hayes trial as well. Okay, and Keith, talk to us about that, because you've got a defendant here, Michael says, smash and grab kind of guy, albeit a guy who's been arrested over 20 times. But at the same time, he's never done something like this. What do you attribute that to, other than Joshua Komisarjevsky's influence? Because it seems like Joshua Komisarjevsky also didn't have a history of such a high-level crime. Maybe the burglary, maybe sneaking into people's homes, but nothing like this.
Yeah, I think the watchword in this case, and Tom Ullman seemed to repeat this, the defense attorney, several times, was things got out of control. It's interesting to note, I was looking back through some of the material from Jonathan Mills, which was the last death penalty case in here, Connecticut, was also Judge Blue, Mike Darrington, and Tom Ullman trying the case. That was a catchphrase during that case as well. It just got out of control. Certainly, these guys have long, extensive criminal histories. They both have troubled backgrounds, and that troubled background is going to be the kind of mitigating factor that Tom Evidence is going to put in. to evidence during the penalty phase. But in terms of what caused, Jonathan Mills to suddenly click from doing petty burglaries and these guys to kind of click from doing the kind of crimes they were doing into something like this, there's no telling what was going through their minds at that moment. What switch flipped, you can only speculate.
Okay, and Keith, take us, you're a defense lawyer, you talk about the troubled background, and again, it's going to be the prosecutors in the penalty phase arguing about the aggravating and the defense arguing about the mitigating factors. How do you present this? Because some people might say, hey, a jury's hearing this, and it doesn't matter what was going on in their background. This went so far that it's unbelievable to think that they deserve anything other than death. As a defense attorney, how do you argue those background troubling factors?
Yeah, and again, I keep touching back on Jonathan Mills because it was the last death penalty case here, and we have a complete record of that all the way through. And in his case, he had a fairly brutal childhood. His father was physically and verbally abusive. He was taught to steal by his father at an early age. He was addicted to drugs. He committed a lot of his crimes in order to get money to get drugs. So these are the kind of things that the defense is going to put on as potentially mitigating factors. In this case, I don't think the backgrounds are as abusive. I mean, certainly you have Commissar Jeffsky, when he eventually goes to trial, he seems to have had a fairly privileged upbringing. He had some psychological problems as a youth. That's going to be seen as a mitigating factor. Hayes, you look at his background and you don't see a lot of mitigation there.
All right, Keith, and
it's a tough case for Tom Olin.
I think Barbara is reflecting a view that a lot of people feel, and we're seeing the kind of pain that family members go through. I want to ask you, Keith, what I just kind of talked to Beth about, which is prosecutors charging this kind of case and pursuing the death penalty. This seems to me why it's so important to keep in perspective and to take into account what the victims want, because there is so much pain and so much they've gone through, and in many ways they want justice.
Yeah, in the state of Connecticut, the prosecutor has the ultimate decision as to how to go with the trial and with the charges, even on the lesser crimes. I mean, I practice here in Connecticut. I live here in Connecticut, and when I'm dealing and talking to the prosecutors for my clients, they will always call the victim and get the victim's input, especially if we're making some kind of deal. But ultimately, it's the state's attorney who decides what the charge is that is appropriate for a particular crime.
Keith, let me ask you quickly. We're looking at the next phase of this. As hard as it's been for the Pettit family, now they have to hear about the aggravating factors from the prosecutor and all the mitigating factors. They'll be right there in that courtroom. How difficult of a task is it for the Pettit family to sit through yet another phase of this? Give us your insight on that, because I feel for this family having to go through this next phase, yet it's a part of our trial system.
Well, I think it's been said before that the state's attorney has probably told Dr. Pettit he's been through the worst. He's seen all of the state's evidence already. To sit now and listen to why Hayes should not be given the death penalty, it might sound from some people's perspective to be a little hypocritical, because here's what this guy has done. Now we're going to tell you he had a bad childhood, or he's got a drug problem. This is supposed to be excusing. I can imagine it's going to be extremely difficult to sit there and listen to people, listen to his parents talk about what a good person he is, or his friends talk about how remarkable it is that this happened and that he's in this position. They don't understand it. But Dr. Pettit has shown remarkable strength and constraint and reserve during the course of this trial, and I think he'll approach it the same way he's approached every aspect of it so far.
Keith, I couldn't agree with you more. Unbelievable strength we've seen from Dr. Pettit. And Keith, really quickly, you talk about the Mills case, the last death penalty case where you had a death penalty guy there, and you talk about how brutal that crime was. As you look at this case, would you walk into this expecting the jury to side on the side of the death penalty?
In that case, I thought the jury was going to decide in favor of the death penalty, and you never know what a jury's going to do. In the Mills case, 2 of the jurors had children. During the course of deliberations, one juror had a daughter, his wife had a daughter, and another juror had a grandchild, and they felt like somehow life goes on, or it was a sign or something, and they came back with life in prison without the possibility of parole. And if there was ever a poster child for the death penalty, it was Jonathan Mills, in my opinion. So, again, you never know what's going to influence the jury's decision in a case like this.
Okay, good point, Keith. And, all these factors will come in. We'll learn all about Stephen Hayes' life. He's even got a family as well. That might be factors. in what his sentence ends up being. Thanks, Keith and Beth. Let me get the prosecutor and the defense attorney on this. I'm going to start with the defense attorney now. Keith, as you look at this, Chuck makes a really good point. We sentence people to death in this country, and they remain on death row, sometimes until they die. Does that really serve the purpose of the death penalty? Should there be a way to maybe speed this up a little bit?
I don't know if it necessarily serves the purpose of the death penalty, but some people would argue it serves the interest of justice because this penalty is so final. You want to have an extensive appeals process, and here in Connecticut, there's an automatic appeal and review to the state Supreme Court. You can appeal it through the regular appeals court. There's a habeas appeal for ineffective assistance of counsel, and then, of course, you can appeal it all the way up to the United States Supreme Court. I think a lot of people, the problem they have with the death penalty is not that it exists, but that it's so convoluted in how you implement it and get through this appeals process that if you were able to streamline it and make it less convoluted, I think a lot more people might be for it.
Keith, I want to talk to you about that. Have you heard this before? People saying, you know what, life in prison in many ways is a lot harder than maybe you get the death penalty, you have lethal injection. What is that process like for people on death row?
Yeah, absolutely. I practice here in Connecticut. I live here in Connecticut. I have friends and family here. And the pervasive attitude, there's a real hang-em-high attitude about this particular case that I haven't seen before with any case or death penalty case. People I know who are fairly liberal, who are fairly forgiving, who don't believe in the death penalty, who are on the fence, are coming up with some really horrific medieval ways of meting out justice in this case. I mean, it's really shocking. She's saying lethal injection is too easy. You fall asleep. These guys should be made to suffer. They should have the same horror visited on them time and again that they visited on the family. It's really raised social consciousness in this state about this issue to a whole new level.
We can never know what a jury's going to do, but looking forward to the penalty phase, given the climate, what you've seen of this jury, do you think that there is a better chance than not that he will actually receive the death penalty?
You know, I think given the charges and the evidence and how they've already come back, I think there's a very good chance that he will get the death penalty. But again, you put 12 people with different personalities in a room like that, there's no telling how it's going to go. So, as attorneys, we always sit there in the courtroom while the jury's deliberating, armchair quarterback. I saw this one look in this direction.
Right.
This guy looked at the defendant. That means he's for us or he's for them. You really can't tell, and you run yourself ragged trying to figure it out.
You never know when you've got 12 people in a jury box. Keith, thanks so much for your time this morning. We so appreciate it.
Thank you.